Good afternoon and welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll, and today we're going to look at, and just briefly, a litigation tip. So our litigation tip of the day, it's going to concern standard of review, just basic standard of review. We know there are many types of standards of review for an appellate court, but one of the first things you need to ask yourself when you get an order from the court and you want to appeal, look at the order. What kind of order is it? Number one, was that order actually prepared by the trial judge himself or herself with his or her own findings, independent thought, and analysis? Or number two, was the order submitted by your opposing counsel, draft proposed order, and it was signed by the trial judge verbatim, or even close to verbatim? That's critical because you have a lot of orders which are certainly subject to an abuse of discretion standard. Okay, that's the most common standard of review. But if you have an order that does not reflect the independent thought and analysis of the trial judge, guess what? Your standard of review is de novo. All right, that's a very, very important fact and principle to remember. The standard of review is going to definitely have an effect on the outcome of your appeal. So you're going to want to look at those questions, answer those, and that's going to help you determine whether you're going to be able to use the de novo standard of review. And you have some orders, of course, that will be subject to de novo, but most are abuse of discretion. But with that principle, you can flip what may be an abuse of discretion standard review, you can flip it to a de novo if that is what in fact occurred in the trial court. Okay, so what the appellate courts have held, and I'm going to cite a couple of cases that you can rely on for this principle that we're talking about. The practice of a trial judge adopting verbatim a proposed final judgment without making any modifications, additions, or deletions, and without making any comments on the record even prior to entry of the judgment is frowned upon. And that's Perlow. That's a basic Florida Supreme Court case from 2004. You should definitely have that in your repertoire. That is Perlow v. Berg, Perlow, 875 Southern 2nd, 383, page 389. And that's a Florida 2004 case. Very significant. And another case, and I like this case, King versus Farah and Farah, PA. That's 358 Southern 3rd, 1271. And 2023 case. So, quote, submissions by the parties cannot substitute for a thoughtful and independent analysis of the facts, issues, and law by the trial judge. There is an appearance that the trial judge did not exercise his or her independent judgment, especially when the judge has made no findings or conclusions on the record that would form the basis of a party's proposed final judgment. And what the court in that case held is that this type of proceeding is fair to neither the parties involved in a particular case nor the judicial system. So true. So the courts are trying to avoid an appearance of impropriety. You have enough of that that the public looks at every day and really hurts our profession. And what the court said in that case, the appearance of impropriety exists when the trial judge adopts verbatim one party's one-sided final judgment, especially where the judge did not orally announce the findings or rulings during or at the end of the trial. And this is instead of thoughtful and independent analysis. And that's what you want. Thoughtful, independent analysis of the facts, issues, and law by the trial judge. And so often, the reality is, you have some judges do that. They do the independent and thoughtful analysis, but you have many judges who are overwhelmed, whatever reason, and they'll sign off on the proposed order or judgment submitted by one side without making any additions. And it should be frowned upon. And the appellate courts have come out and said they frown upon it. And if that's done, what would be an abuse of discretion standard review now becomes a de novo standard review. As you know, de novo, the appellate court will sit in the place of the trial judge and now can look at the case as if it's first impression before it. So that's a fundamental principle I think you need to be aware of. And that's our litigation tip for today. As usual, any questions, let us know. Thank you. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.